morning because it's different depending on where you are, but I do call this meeting to order. Welcome to meeting number 21 of the Special Committee on Canada-China Relations. Today's meeting has been requested by 4 members of the committee pursuant to Standing Order 106-4. For votre information, l'article 100...
For your information, Standing Order 106-4 applies to this, and pursuant to this motion, today's meeting is a hybrid meeting.
Dr. Jenis, I wish to say a few words regarding parliamentary privilege and the obligation of witnesses to answer questions. Parliamentary privilege stems from the Constitution Act 1867 and refers to the powers, rights, and immunities that are deemed necessary for the House of Commons and its members to fulfill their functions. Among those rights is the power to conduct inquiries, summon witnesses, and order for the production of documents. The House delegates those powers to the parliamentary committees it creates. The Parliament of Canada Act is also central to the power of committees to obtain pertinent and truthful testimony. It also provides for freedom of speech to all committee members, as well as to all witnesses appearing before the committees. Witnesses must answer all questions from committee members. On the other hand, members have been urged to display, quote, appropriate courtesy and fairness, unquote, when questioning witnesses. Committees ordinarily accept the reasons given by a public servant for declining to answer questions which may involve the giving of a legal opinion, may be served as a conflict with the witness's responsibility to the minister, may be outside of their own area of responsibility, or may affect business transactions. It is up to the committee to accept or reject the reasons provided by the witness. Should the committee, reject the reasons provided by the witness and the witness still refuses to answer, the committee may report the situation to the House. Matters pertaining to parliamentary privilege can only be decided by the House, and only the House can intervene in cases where it deems that parliamentary privilege has been breached. J'espère.
I hope that all this has clarified the situation. I'd now like to thank Philippe Dufresne, Law Clerk and Parliamentary Counsel, as well as Michel Bédard, Deputy Law Clerk and Parliamentary Counsel, for their presence. I'd also like to thank them for having provided us with a legal opinion in writing on the situation underway. I asked them to be present here today in order to answer any question by members of the committee.
So wish to inform committee members that the Minister of National Defense has confirmed his appearance for Monday, April 12, 2021. And now I would like to turn the floor to Mr. Jenis. If you wish, you may now move your motion and speak to it. I will then call, pardon me, I'm sorry, I'll turn that off. I will then call for debate and establish a speakers list. Please proceed.
Well, thank you very much, Mr. Chair, and I greatly appreciate your opening comments. I move the following motion, that the committee order the production of all information and documents in the possession of the Public Health Agency of Canada or any subsidiary organizations relating to the transfer of Ebola and Henipah viruses to the Wuhan Institute of Virology in March 2019, and the subsequent revocation of security clearance for and termination of the employment of...
Sorry, I'm in virtual committee. I got to go. Oh.
Mr. Chair, you're off mute here.
I'm back on mute. My apologies.
Okay. I'll just go back a couple steps here. Viruses to the Wuhan Institute of Virology in March 2019, and the subsequent revocation of security clearance for and termination of the employment of Dr. Changgu Chi and Keating Cheng, provided that A, these documents shall be deposited with the clerk of the committee in an unredacted form within 10 days of the adoption of this order. B, the committee requests the law clerk and parliamentary counsel to provide advice in writing in relation to whether and how to release all or some of this information and documents publicly. And C, until it has considered the law clerk's advice, the committee keep the information and documents confidential, except that they may be shared with the Office of the Law Clerk and Parliamentary Counsel as required to prepare the advice requested under paragraph B. That is the end of the motion. Mr. Chair, I'd like to make a few opening remarks about this motion, and I certainly look forward to the committee's discussion. Conservative and Bloc members of this committee have sought this emergency meeting out of a powerful sense of the enormous stakes in this matter. Substantively, we have a situation in which deadly viruses were sent from a Canadian lab to the Wuhan Institute of Virology, a lab in China with connections to the Chinese military, which engages in so-called gain-of-function experiments. Gain-of-function experiments are experiments whereby efforts are made to make a virus more deadly or more contagious for research purposes. Concerns about the security protocols of this lab had been previously raised by American officials. Needless to say, the sending of viruses from a Canadian lab to a Chinese military-affiliated lab which does gain-of-function experiments raises serious questions for national security and global health, questions which are germane to this committee's current study on national security in the context of the Canada-China relationship. Shortly after the transmission of these viruses, scientists involved were expelled from the Winnipeg lab for alleged policy breaches. That's all we know, policy breaches. But we are still being told that the export of viruses aligned with protocols, and we still don't know exactly why the scientists were expelled. During our last meeting, MPs from all opposition parties sought answers to these questions from Ian Stewart, President of the Public Health Agency of Canada. Questions were asked at both the general and specific level. For example, my questions did not mention the cases of the specific scientists involved. I asked the following question. Mr. Stewart, has there ever been a case where any lab has fired scientists as a result of security breaches or the improper transfer of viruses? He refused to answer that question. I repeated, Mr. Stewart, this is a critical issue of national security. Has any lab in this country ever fired a scientist as a result of a security breach or the improper transfer of viruses? You're a public servant. People deserve an answer. Again, he refused to answer. Given the issues at stake, there is obviously a profound public interest in this committee accessing this information. But it is also very clear that this committee has a right to access this information, a right established in law, in our constitutional traditions, and in the past practices of parliaments and parliamentary committees. I'll have a bit more to say on that in a moment. But before going into that specifically, I want to say that what is at stake here is more than just the substantive issues of national security and public health. Through the defiance of Parliament and the defiance of law by a senior public official charged with discharging public functions on our behalf, the President of the Public Health Association of Canada is asserting an aristocratic as opposed to a democratic principle of governance, which is alien to our traditions and values. He is asserting that public officials who have heretofore been thought to discharge public functions on behalf of the public should no longer be accountable to Parliament, or at least should be able to control the issues on which they are and are not accountable. In cases where he deems fit, this official is seeking the right to make decisions, draw conclusions, and shift policy responses on his own, entirely insulated from public or parliamentary scrutiny and evaluation. This is simply not how our system is supposed to work. We have a system of responsible government, hard-won and maintained only by the vigilance of Canadians and parliamentarians. The essence of responsible government is that members of the executive and public officials who they appoint are responsible to the democratically elected legislature for the decisions that they make. If officials can refuse the production of documents at will, then we have allowed an attack upon a core principle of responsible and democratic government, replacing it with a kind of aristocratic governance in which accountability is circumscribed by public officials. Mr. Chair, the proper function of an expert or a functionary in a democratic society is to advise decision makers and to carry out their direction. Fearless advice and faithful implementation. Politicians are often wise to trust that advice, but they may also challenge the views of some experts by consulting other experts. And as our system currently operates, not every public servant who is appointed to lead an agency is an expert in the subject matter of the work of that agency. We have come to recognize the superiority of responsible government over aristocratic government. Government of elites may have expertise on the implementation of certain technical matters. However, government which is responsible to Parliament and through Parliament to the people is necessarily more responsive to the ends identified by the public. Aristocracies can furnish proposed paths to their desired ends, but democracies define the public interest in a way that accords with the legitimate aspirations of the greatest number. Our system of interplay between the public service and the people's representatives allows us to leverage the technical expertise of a professional policy proposing class while also ensuring that democratic legislatures ultimately define the ends to which public policy is directed and are empowered to correct and redirect bureaucracies when their proposed objectives do not align with the public interest as defined by the legislature. The testimony of the President of the Public Health Agency of Canada, by asserting a new aristocratic right not to be accountable to a parliamentary committee, proposes to upset the critical and finely tuned balance which has up until now provided us with peace, order, and good government. We should not take this effective challenge to parliamentary supremacy lightly or fail to take a stand in response to it. Now, lest there be any doubt as to whether Parliament has these rights, I want to briefly respond directly to the arguments made by the President of the Public Health Agency of Canada that he does not have to provide documents because of provisions of the Privacy Act. I believe that he is wrong about the Privacy Act, but the more important point is that the Constitution of our country, which defines the rights and privileges of Parliament in its pursuit of democratic accountability and the public interest, supersedes the Privacy Act. If a statute is found to conflict with the Charter of Rights, we all understand that that statute cannot operate in that case. The same principle applies in the case of constitutional provisions around the powers of Parliament. The Standing Committee on Procedure and House Affairs report from the 41st Parliament entitled Access to Information Requests and Parliamentary Privilege points out, since parliamentary privileges form part of the Constitution, laws must be interpreted and applied in a manner consistent with them. And where there is a conflict between privileges and statutory provisions, the statutory provisions are of no force and effect to the extent of the inconsistency. This constitutional principle is a fundamental postulate and organizing principle of the Canadian constitutional structure and is clearly set out in subsection 52(1) of the Constitution Act 1982 that provides, quote, the Constitution of Canada is the supreme law of Canada, and any law that is inconsistent with the provisions of the Constitution is, to the effect of that inconsistency, of no force or effect. That's from the quote of the Standing Committee on Procedure and House Affairs report. Now, House of Commons Procedure and Practice also notes the following. No statute or practice diminishes the fullness of that power rooted in House privileges unless there is an explicit legal provision to that effect or unless the House adopts a specific resolution limiting its power. The House has never set a limit on its power to order the production of papers and records, period. So, Mr. Chair, the precedents on this are numerous and well known, and I don't think I need to quote them any further. But of some importance as well is the fact that there is actually not a case of conflict here between the Privacy Act and the constitutional rights of parliamentarians, because the Privacy Act specifically envisions a situation like this and defers to us in that case. My colleague, Mr. Chong, is going to develop this point further with reference to specific provisions in Section 8 of the Privacy Act, which says that information may be disclosed for the purpose of complying with a subpoena or warrant issued or order made by court, person, or body with jurisdiction to compel the production of information, or for any purpose where the public interest in disclosure clearly outweighs any invasion of privacy. So, Mr. Chair, colleagues, we have in front of us an issue that raises questions of national security, public health, and the enduring conflict between responsible government and aristocracy. I am proud that members of multiple parties have already taken a clear and principled stand on this issue, and I hope that other members of this committee will as well. The motion that I have put forward is reasonable and balanced. It provides a responsible mechanism for responsible exercise of this committee's rightful prerogatives. This committee has the right to request all documents unredacted right away and for public disclosure, but we have a responsibility to exercise our functions in a prudent way that advances the public interest, which is why the motion as drafted seeks documents to be sent to the law clerk and then from the law clerk to the committee for its consideration on what to make public and what not to make public. I believe that this motion is a responsible way of rebuking the illegal pretenses of would-be aristocratic public officials and ensuring that people are held accountable for serious breaches of national security so that we can assure Canadians that these kinds of breaches will never happen again. Thank you, Mr. Chair.
Thank you, Mr. Janis. Mr. Janis, can you confirm whether the clerk has asked me a question? Is the wording of the motion you presented today the same as the one of which you gave notice? Is there some small difference, just so we understand?
The motion that I read out is identical to the motion that we gave notice of, and if in any way is not, that was an error in my my reading of it.
Thank you so much. So the members will, if I'm not saying that there was, I don't know if there was any difference. But members will, I'm sure, be glad to know that they can refer to the notice which contains the wording of the motion. Mr. Chong.
Thank you, Mr. Chair. Mr. Ian Stewart, in his letter to our committee, Mr. Chair, indicated that he could not release the documents and information that we had requested because it was personal information, and he indicated in his letter that the Privacy Act prevents the release of personal information under the control of a government institution. I don't know what legal advice he got, but I think it's incorrect. He says in his letter that the Privacy Act provides that personal information under the control of a government institution shall not, without the consent of the individual to whom it relates, be disclosed except in accordance with the circumstances described in subsection 2 of the Privacy Act. He then goes on in the letter to indicate that the and implies that the only way in which he could release that information to the committee is under paragraph 8, subsection 2G, where the person in question whose information we are seeking would have to consent to that release. That implication that that's the only way in which he can release that information is incorrect. And I'd like to draw to the attention of the committee from the same section of the Privacy Act, the same paragraph of the Privacy Act, Article 8.2c. And I just want to read it out. It's very short. Article 8.2c says, quote, subject to any other act of Parliament, personal information under the control of a government institution may be disclosed for the purpose of complying with a subpoena or warrant issued or order made by a court, person, or body with jurisdiction to compel the production of information, or for the purpose of complying with rules of court relating to the production of information. So Article 8.2c clearly says that personal information under the control of the Public Health Agency of Canada may be disclosed for the purpose of complying with an order made by a body with jurisdiction to compel the production of information. Mr. Chair, we are a body with the jurisdiction to compel the production of information. So I don't know what legal advice Mr. Ian Stewart got, but it is incorrect. We are a body with the jurisdiction to compel the production of information. We adopted a motion calling for the production of that information. That motion is an order to compel the production of information, and the Public Health Agency of Canada needs to comply with that. In fact, the Privacy Act was written with the Constitution in mind. As you mentioned in your opening remarks, Mr. Chair, it was written with the Constitution's provisions that promulgate the ancient rights and privileges of Parliament, one of which is to compel the production of information, to compel the production of documents. And I quote from House of Commons Procedure and Practice, which describes this power. The standing orders state that the standing committees have the power to order the production of papers and records, another privilege rooted in the Constitution that is delegated by the House. House of Commons Procedure and Practice goes on to say, the standing orders do not delimit the power to order the production of papers and records. There is no limit on the types of papers likely to be requested. The only prerequisite is that the papers exist in hard copy or electronic format and that they are located in Canada. It goes on to say, no statute or practice diminishes the fullness of that power rooted in House privileges unless there is an explicit legal provision to that effect or unless the House adopts a specific resolution limiting the power. The House has never set a limit on its power to order the production of papers and records. And finally, it states, in cases where the author of or the authority responsible for a record refuses to comply with an order issued by a committee to produce these documents, the third option is to reject the reasons for denying access to the record and uphold the order to produce the entire record. In other words, what we are doing today, Mr. Chair, is we are rejecting, in this motion, if it were to be adopted, we are rejecting the reasons that the Public Health Agency of Canada has given in denying this information. And we are upholding the previous request that we made last week. And so, Mr. Chair, I strongly urge members of the committee to support this motion. I'll finish by saying this. Speaker Milliken, who was a great Speaker of the House of Commons, reaffirmed these ancient privileges of the House under the Constitution and under law to order for the production of these papers. He confirmed it in his ruling of 2010, when he ruled on the Afghan detainee document, and he confirmed it in his precedent-setting Commonwealth parliamentary ruling, in his ruling in the House that set a precedent for parliaments throughout the Commonwealth, in his 2011 ruling that compelled the Harper government to release financial information concerning a range of matters, including the costing of the F-35 jets. And I supported Speaker Milliken's ruling at that time publicly. And I'm urging members of the committee to uphold the powers of this committee and the House in general and support this motion. Thank you, Mr. Chair.
Thank you, Mr. Chong. Mr. Harris. Mr. Harris.
Yes, thank you, Chair. I was just busying myself to unmute so I can be properly heard by the committee and anybody watching. I want to say, first of all, that I support this motion. The wording I will have some comment on, but I do wholeheartedly support the motion to obtain the documents requested. And I think it is, I won't go into all the legalities. I think Mr. Genuis has covered the field, as it were, but I will rely on the ruling of Speaker Milliken, that very important ruling that was made in April of April 27th, 2010, and the ruling of March 9th, 2011, which dealt with the Afghan detainee documents. I think I want, first of all, to thank the parliamentary law clerk and counsel, Philip Dufresne, for his excellent exposition of the rules and law with respect to the power to send for persons, papers, and records in his letter to you, Chair, of March 31st, 2021. And I would commend it to all parliamentarians to look at it as a concise and thorough exposition of the principles involved. Some of them are legal principles, and they are, of course, legally binding, but they are also important constitutional principles which govern our parliament and the right of parliamentarians. I'm also moved to say that I'm pleased to hear that this motion is coming from the Conservative Party of Canada. It was and supported by Michael Chong, who also supported these rulings back in 2010 and 2011, which were not really supported by his government. His government were opposing that. So I'm encouraged by the fact that we now have the Conservative Party of Canada standing strongly and firmly behind these rules as they pertain to the right and duty, in certain cases, obviously, of members of Parliament to have access to and seek access to important documents that are under control of the executive and under the control of the bureaucracy in some cases, but also the understanding the principles that are involved. So I think we are it's a very important exercise that we are looking at today, and I think it behooves us to look at it quite carefully and consider what it is we are doing and how we are doing it, because I think both of these things are important. As noted by the law clerk in his paper and letter sent to us, that the powers of committees to order the production of documents and records is not limited by law or by the House of Commons rules of procedure, and Parliament is not, as is pointed out here, bound by the Act. But as pointed out in the document of a report of the Standing Committee on Public Accounts in 2009, the power of committees to order the production of documents and records is the title of it. It says that the power to send for records has been delegated by the House of Commons to its committees in the standing orders of the House of Commons. A committee's power to call for persons, papers, and records is said to be absolute, but seldom exercised without consideration of the public interest. And I think that's the nub of what we are doing here today in this motion. We are exercising the rights of parliamentarians to have access to documents and records, and I think they're important. It's not done lightly, and as been pointed out by Mr. Genuis, the importance of the question at hand is significant, as was the issue that gave rise to the rulings of Speaker Milligan in 2010 and 2011, and this was known in shorthand as the Afghan detainee documents, which were relevant to the question that was being pursued at the time as to whether or not Canada had been complicit in torture in Afghanistan during the war there in relation to persons held and detained in prisons in Afghanistan. It was an extremely important question as to how Canada had undertaken its obligations under international law. So it's not done lightly, but when it is done, it's done within the powers of the Constitution, as expounded by Speaker Milligan. And Mr. Chong just said that Speaker Milligan confirmed the existing rules. However, I think it's important to note that that decision was probably the first one in all of the British Commonwealth of Nations, the Commonwealth of Nations or parliamentary democracies that had gone so far and so detailed in that on principle, and very rare for that level of decision to be made because it's very rare for it to come to that kind of ruling. But we are lucky as a country to have that ruling as a guiding principle, and I think certainly given the conservative support for this that we're seeing, Conservative Party support, I think it's now well settled that this is the law in Canada, and this is the parliamentary procedure under which we should operate. So, having said that, I think I will. I'm not going to move the motion right now. I'm going to listen to the debate, but I will have a motion to amend paragraph B of the order. To try to find a way, and we may need to ask questions of the parliamentary clerk as to how this might be done, but I'll give you the gist of it, Mr. Chair and members of the committee, that rather than asking the law clerk to redact the documents, that the law clerk should discuss with the committee in an in-camera meeting that documents, the information contained therein, which in his opinion may reasonably be expected to compromise national security, and this I'm reading from the existing one, or reveal the details of an ongoing criminal investigation, and so as to determine by the committee which records might be made public or made available to the committee, so that the committee would be involved in this. Going back to the Afghan detainee situation, I think it was mentioned before in this committee that one party didn't participate in the actual examination of the documents after the ruling had been made. And I will explain that for the benefit of members of the committee and for those who may be paying attention, that is correct, because what had happened after the ruling was made, in an effort to seek a method of following the ruling that had been made by the Speaker, a committee was struck between all parties in the House. I was a representative on that committee. The committee, without the committee by majority, ruled that the committee itself that was looking at these documents or was entitled to these documents would not actually see the documents, that they would be handed to a third party, in that case, former Chief Justice Frank Iacobucci, to look at all the documents and make them available to the committee, which he, in his opinion, thought that was appropriate to be passed over to them. We did not agree with that because it was contrary to the motion. We believe that other measures could have been taken to ensure whatever requirements of national security and the public interest could have been undertaken by the committee. So that is a principle that I want to see upheld in this particular exercise. I did not sign this letter. I see that 5 members of the committee have done so. I was invited to do so, and I urged the mover to proceed with the motion, but I didn't want to be committed to the wording that was contained in it because of the matter that I just raised. So I do think we should have a method of dealing with the public interest in this matter, as we should do as parliamentarians, but to do so in a way that does not limit or does not accept a limitation on our powers. And we have to be, as parliamentarians, of course, mindful of our obligations and our own oaths of office, and that we would exercise them in that manner with the assistance of and the guidance of and the advice of the Parliamentary Council and the legal advisor. And that's the gist of what I have to say. The wording of that motion, and perhaps some comment from the other members of the committee and the Parliamentary Council and our law clerk would be important to this discussion before I would move a wording in its exact move a motion in the exact wording. Thank you, sir.
Thank you very much. I have on the speakers list Mr. Oliphant and then Monsieur Bergeron. Mr. Oliphant.
Thank you, Mr. Chair, and it's good to be back with friends at this committee. He may be girding his loins right now, but he doesn't need to. I'm not going to be arguing against Mr. Jennis's argument. I think it is very clear that we have the constitutional authority as the legislative branch and the supremacy of Parliament to order papers and to summon witnesses. I will not argue against that. I have argued for that in that same time as Mr. Harris was referring to, and I will continue to argue that Parliament has the right to order papers and to summon witnesses and to do that work. And the oversight of government, the executive branch, including its administrative branch, is our responsibility. So that is not an argument that I will make. And as uncomfortable as I am agreeing with Mr. Jennis in his argument on that. I'm also not going to argue with Mr. Chong. I actually, when I read the letter from the Public Health Agency of Canada, I disagreed with it. I think that there was a confusion between our right as members of Parliament to work on individual cases, such as immigration or CRA cases, and our responsibility to do that for our constituents. However, I do follow the practice, which I think is standard, that we receive waivers from individuals to make sure that we can act on their behalf. And that makes sure that we are consistent with the Privacy Act. However, I think that the section that Mr. Chong cited is actually more appropriate. And I would say that I hope that legal counsel to the Public Health Agency of Canada will listen to Mr. Chong on that and investigate further the right and the responsibility of a parliamentary committee following under the rules of the House and the purpose of the House to oversee government and its agencies. So I'm not going to be arguing with Mr. Chong on that point as well. And I'm not going to be arguing with Mr. Harris. Here's the point. And I feel like I keep getting further out on a branch because I'm not arguing with Mr. Harris too on his points with respect to Speaker Milliken's rulings, both with the Afghan detainee papers, which, like Mr. Chong, I supported. However, I was in opposition, so it was a much more comfortable place to be than he found himself in at that time. And I also would point out, however, that Speaker Milliken was very judicious in that ruling. And he felt that public interest had to come into the responsibility that parliamentarians maintain. And that public interest is not always served by us exercising to the full extent of the rights and privileges we do have. And I think those who are at the Foreign Affairs Committee, when a similar issue was discussed recently, will recognize that I will always want to retain the right of Parliament and its committees to call upon witnesses and the production of papers. We have that right. We should always retain it. However, like Mr. Milliken in his ruling with respect to the Afghan detainee papers, I think we need to find the most appropriate way to exercise our right and our authority in a way that does not undermine the public good. And we have recognized this as an art and not a science. That art is something that we need to be very cognizant of. So I think we need to pull back from some of the partisanship that I think is behind this motion. I don't think it's all partisan. I think there are principles here that are at stake as well. And look at what is the best way to go forward. I would argue, as Mr. Janice did, we have the right. I'd argue that Mr. Chong is correct, that is an inappropriate understanding of the Privacy Act, always understanding that our constitutional authority supersedes legislative authority. The Public Health Agency of Canada and all government departments, as well as agencies like PHAC, will have to, they're under legislative obligations, which we are superseded by our constitutional authority. We understand that. However, there are some factors in this particular case that I think we need to take into account about how we move forward on it. Absolutely, we have the right. Now, in that, I also want to thank the law clerk once again for providing in writing his understanding of our authority, which I found, again, it echoed things that he has said in committee before, as well as in advice I have sought from him as a parliamentarian. And he has given us our, as our lawyer, he is our lawyer, and as a good lawyer, he has given us legal advice. However, even as I would reject the Public Health Agency's argument, I want us to exercise more caution with respect on this in a couple of fashions. The first is, we understand that there is a police investigation underway with respect to this matter. And there are two sort of branches of this request. One has to do with the Public Health Agency of Canada. The other has to do with the RCMP. And I am long an advocate for parliamentary oversight of the RCMP. I have fought for that in opposition. I will continue to always stress that RCMP needs to be under the oversight of Parliament. It needs to have civilian oversight. I have been stressing that time and time again. However, when there is a police investigation underway, not yet complete, we have to step back from that and understand that our police agencies, and particularly the National Police Force, the RCMP, has its responsibility to undertake its work. And so I'll just be asking the law clerk a little bit for his advice with respect to, is there, I'm not right away, but just to give him a little notice, is there a limitation on our access to information as parliamentarians from a police force while a current investigation is underway? And should we be cognizant of that? It is very important that we never have any political interference or even the appearance of interference in a police investigation. Once that investigation is finished, we have the right and the responsibility to exercise oversight and that kind of stuff. But to engage within the context of a police investigation, I think is problematic. So that would be one concern I have. The second concern I have is with respect to national security issues. And I haven't seen Mr. Harris's amendment to that yet. I will be interested in it, but my caution on that is twofold. First of all, I, as an individual MP, do not feel that I have the full base of knowledge to fully understand national security impact of actions. That's why we have officials. That's why we have experts. That's why we have people who actually do that for their job and make, perhaps imperfect, but to the best of their ability, judgments based on what indeed the national security implications of an action are. And there are teams of people who do that. The government is full of people doing that, and they are necessarily conservative, small c conservative in their approach, because they want to ensure that the safety of Canadians and the safety of Canada's position in the world is guarded and maintained. We have relationships and we have security issues that I do not feel that I have adequate information or access to all of that information. I don't have the security clearances to even receive it. But also, this is worldwide. There is always going to be a limitation on what we are able to receive because of that. And while we have the right, as I said earlier, whether we exercise that right is very important to the matter of public interest. The second question I would ask the law clerk is about, and this comes from, and we have not yet seen it, but the amendment proposed by, or at least given notice of by Mr. Harris, would indicate that the law clerk of the Parliament of Canada has the competency and the staff and the knowledge to determine what is a matter of national security. And I'm going to say I'm naive. I don't know that. That has not been my understanding of the knowledge and the experience and the expertise of the law clerk of Parliament, the Parliamentary Law Clerk's office. They have expertise in understanding the laws related to our privilege, understanding offering us legal counsel as our advocate, absolutely. But whether or not they have, he and his staff have the competence, the ability, and no, with all due respect, they may have that, but it's not been in my experience that they have the knowledge to understand the intricacies of a public safety issue and a national security issue that could be revealed by certain information. I think that they have shown at the Finance Committee, they have the ability to look at a redacted document and find reasonableness in the arguments made for the redactions. I think the Finance Committee found that helpful to have the law clerk look at a redacted document and an unredacted document and ensure that there was a reasonableness factor to that, that there were criteria that were set and established that made sense to the law clerk so that he could advise the Finance Committee on the reasonableness. We've also at the Foreign Affairs Committee held open the possibility that he could do that on other documents. I think reasonableness with respect to the concept of privacy, the rights of individual to expect privacy in their engagements, or with respect to commercial obligations of sensitive information, absolutely, that is within his realm of expertise. I am concerned that the decisions with respect to a national security issue may fall outside of that. So while I have really strong agreement with Mr. Janis's motives on this and his arguments, and strong agreement with Mr. Chong's arguments on this, and with Mr. Harris's, with the caveat that when Speaker Milliken made his first ruling, the very important ruling with respect to Afghan detainee paper, he didn't just simply say, I'm going to demand it. He gave Parliament 2 weeks to engage in a consultative process that both involved legal jurists, particularly, there was actually a panel of 3, I believe, looking at the documents, and then bringing the parties together to reach a memorandum of understanding, an MOU, about how they would go through it. I understand the NDP chose to not engage in that once they felt that there was going to be any fettered access to the documents. That was their privilege. The other 3 parties that were recognized in the House at the time did choose it, and then there was a process that was engaged to go through those thousands of pages of paper that was done. But it wasn't unfettered access in the end. It was a negotiated agreement among parties to find the best way forward. So I'm in support of Mr. Harris's amendment in theory, that we find a method, as he said, of dealing with this to protect the public interest. I am just not sure the one that he has suggested would be the right one. So I put then on the law clerk 2 questions that the chair can decide when it's appropriate for him to answer. One is with respect to the nature of this request, given an ongoing police investigation, and if there are any limits to that. I always get that term subjudice or something, subjudice, which I think is I'm not a lawyer, I'm a clergyman, so I'm limited in my vocabulary on that, but I can preach at length. And the second question is on his understanding of their ability to ascertain public security, national security interests, and how he would have that competence in his department. So thank you, Mr. Chair. As you can see, I like the idea that we have this right, but I would be voting against this motion if I feel that there is public interest not being guarded, because sometimes there are interests that are more important than our right to get information. Thank you.
Merci beaucoup. Sur la liste.
Thank you very much. On my list, I have Mr. Bergeron and then Mr. Harris again. And I propose that we go to Mr. Dufresne after that, except if Mr. Bergeron and Mr. Harris propose that we go to him first. Mr. Bergeron. Thank you, Mr. Chairman. I was preparing to begin by saying, first of all, that Mr. Harris could have pointed out that this notice of motion was not signed by only 4 Conservative colleagues. I also signed this motion proposed today, and this is completely in keeping with the Bloc's position on the Afghan detainees. So it seems to me that I'm acting consistently with the positions of my party on these issues in the past. I was concerned, I must recognize, by Mr. Oliphant's claim, according to which he thinks this is a partisan gesture. Mr. Oliphant is starting to get to know me, I think, and he knows full well that I'm trying to stay away from partisan jousting when it comes to foreign affairs. So that is not what has motivated my support for this motion. And I take umbrage at the fact that he may think that that's my motivation for supporting this motion. Moreover, Mr. Chairman, the last words he spoke might shed light on the reasons why he might see partisanship in this motion. Contrary to the position defended by his party when he was in opposition, Mr. Oliphant seems to be supporting the completely contrary position today, now that he's in government. He's invoking the superior interests of goodness knows who to say that perhaps we need to limit the powers of Parliament. What I find particularly concerning, Mr. Chairman, in this avowal by Mr. Oliphant is that he seems to be saying that deep down, if we bring forth this motion, it's not because we're against some civil servant's decision, but against the government in power, as if the government in power right now was supporting the decisions made by the public servant. I never thought that the government in power was sanctioning the position of this public servant not to answer parliamentarians' questions. If I'm to understand what Mr. Oliphant just said a few moments ago in talking about a partisan gesture, is that the government is sanctioning the senior civil servant's refusal to answer, and that's far more worrisome to my mind than it seemed before we met this morning, Mr. Chairman. You will not be surprised to hear that I support fully and without reservation the motion we have before us, for the reasons that were eloquently presented by Mr. Jennis and Mr. Chong. I'd also like to tell Mr. Harris, my friend, that I would have liked to have discussed this with him before this morning and discussed his reservations, because contrary to what Mr. Oliphant's saying, I think that in this motion we do have parameters, safeguards that would allow us not to harm the public interest in any way by exercising the powers devolved to Parliament. Notably under point B, where we are obligated not to disclose everything publicly. I know that Mr. Harris has an amendment proposal for point B. I would have liked to be able to discuss it with him, and I'm totally open to hear what he will have to say in a few moments. But I want to reiterate, Mr. Chairman, that I believe that this motion is balanced, precisely because it contains safeguards that allow us not to violate the public interest simply on a matter of principle. But we're not going to sacrifice principles which are at the very basis of British parliamentarianism just because the government is uncomfortable with the current situation. And up until a few moments ago, I didn't think the government felt that it was being accused of anything here. But Mr. Oliphant seems to be saying that the government is concerned. It's being accused of some problem because the public servant refuses to answer. Now that worries me, because I had no qualms about that before I arrived here today. I'd like to get back to Mr. Harris's intervention of a few moments ago, which seemed to me just as eloquent as those of Mr. Chong and Mr. Jennis. Mr. Harris was saying that in his opinion, the decision made by Speaker Milliken was probably a first in the jurisprudence of decisions made in British parliaments or British-type parliaments. I would not contradict my erudite colleague on that point. I didn't check anything that would allow me to affirm this, but I can say that having sat in another parliament, this decision by Speaker Milliken is indeed a precedent in subsequent decisions by other speakers in other British-style parliaments. And I'm referring, of course, to decisions made by Speaker Chagnon in the Quebec National Assembly. I'd like to close, Mr. Chairman, by saluting the excellent document that was transmitted to us by the clerks of the House of Commons. We'd had the pleasure, those of us who sit on the Foreign Affairs and International Development Committee, we'd had a presentation on the same topic, the ability of Parliament and its committees to require that the government produce documents. So I was not surprised to find all these arguments in this other document, but I want to underscore the quality of the document. It is concise and clear. So, Mr. Chairman, since this document is now public, I believe it can be used as a reference for anyone who wants to take a look at it later. Now, that brings me to a conclusion, Mr. Chairman, about Mr. Oliphant's comments. It seems to recognize that our clerks have the ability to judge commercial question, but not the ability to question one about national security. Other than the fact that I find that comment a little contemptuous about our clerks, because I think they are capable of finding the expertise they need to properly advise parliamentarians. I think that once again, this translates the government's desire to just shut all this down. And once again, Mr. Chairman, I'm worried, I must say, because I didn't think that the government considered that this issue before us today involves it directly. But given this qualifier of partisan that Mr. Oliphant attributed to this motion, I understand that the government feels that it is being somehow accused. Not the public servant or the agency, but the Liberal government itself seems to feel that it is being attacked by this motion. And that is of grave concern to me, and I am eager to see what my other colleagues have to say. Thank you very much, Mr. Bergeron.
Mr. Dufresne, before or after I go to you?
Mr. Speaker, am I on the list here?
Mr. Harris, you're on the list. Would you like me to go to you before or after I go to Mr. Dufresne?
Yes, I did want to mention some that might reference what the response might be. Yes, first of all, I thank Mr. Oliphant and Mr. Bergeron for their interventions and shedding light on their thoughts on this. I didn't by any means mean to leave out Mr. Bergeron as a signatory to the letter. I did point out that there were 5 members of the committee had signed the letter that I was invited to do. So the meeting is called in response to a request by 4 members, but I note, of course, that there are 5 members who've signed the letter. I was invited to do so, and on very short notice, and declined to join in that for the reasons that I think I've discussed earlier. And I'm happy that we're having an opportunity to fully discuss the concerns that I had here today before making a decision, and there wasn't time to do that beforehand. But I think and I commend Mr. Bergeron on his recognition of the Milligan case as being. I don't know if I said the first case. Certainly, it's the leading case on the matter. Perhaps up until then, at that time, the most detailed and fulsome investigation into the whole notion of the relationship between the executive and the parliament in the systems that we share, including the National Assembly of Quebec. And I'm gratified to see that the National Assembly of Quebec itself has rulings that have acknowledged this decision as being an important leading case on which to base the decisions of their National Assembly. It's we do have to come to grips with the national interest in this committee either today or with the after the motion is passed and that we meet with the law clerk. And I'm wondering out loud whether it might be helpful to Mr. Dufresne's comments to have perhaps a little bit more delimitation from Mr. Genuis as to the. I know your motion calls for all papers, etc., and all documents, all information and documentation. Is there any possibility of being a little more specific in terms of what it is that we need information on? What is it that's important that might be able to be responded to by Mr. Dufresne in terms of responding these questions? This generalities such as national security, it seems is so general in many cases as to defy an opportunity for someone to, in the absence of specifics, to even make a determination on it. And I wonder, is there any point, and perhaps Mr. Dufresne might comment on that when he responds, is there any point in being any more specific then the motion is right now, or at least advise what particularly is the information and knowledge that we want to obtain from this investigation. It's obviously been initiated by the efforts of Mr. Genuis and the questions of Mr. Genuis, and I have an idea, but I would perhaps like to be better informed if I heard from him what it is that's necessary for us to know to answer his concerns and questions. That just out there for consideration. Perhaps Mr. Dufresne can go ahead without knowing that, or we can continue the discussion.
Thank you very much, Mr. Harris. I'll go to Mr. Dufresne and then to Mr. Oliphant, and then if Mr. Genuis or anyone else, Mr. Genuis is on the list, then after that, so if that's all right, I'll go in that order. I think that's the proper procedure. Mr. Dufresne, please.
Thank you very much, Mr. Chair, members of the committee. And so to address some of the points and some of the questions, it is a constitutional power that you have as committees to seek for documents, papers, information. As mentioned, and as recognized by Speaker Milliken in his ruling, this power, this right, also brings with it responsibility to exercise it reasonably and with care and having public interest impacts and implications in mind. And Speaker Milliken in his ruling noted the more than 140 years of collaboration between the House and the executive. The House with its role as a grand inquest of the nation, and the executive in that case with the role of defender of the realm. So balancing these and having regard for these important public interest concerns. What Speaker Milliken clarified, however, is that it is for the committees and ultimately for the House to make that determination in the exercise of that power, and that the government does not have a unilateral right to make the determination and to have the House essentially be bound by that determination. Even in a case where there are statutory principles that apply, the House's constitutional authority will supersede that. There were questions about potential impacts on lawful investigations. That's certainly something that's recognized as a public policy concern in the access to information legislation, and it is listed as a ground for redactions under that act. So the question becomes, is this something that the committee will accept as one of the reasons, perhaps considering options of having information in camera and considering whether it should share that information further, or keep that information in camera, again on the balancing of the interest and reducing any harm to the public interest. In terms of national security and other grounds, my office acts essentially as the Department of Justice for the legislative branch, and we provide legal services and legal advice to committees on all areas of law, including all of those potential grounds for confidentiality that committees and or the House may decide to accept or not accept. And so we are prepared and we are able to provide that legal advice in terms of the interpretation of those concepts, including national security, commercial sensitivity, and so on. That being said, there may well be some factual information and knowledge that the government or other entities have that we don't have, because it's their information, it's their concerns, and they may be well placed to share that with us in terms of proposed redactions or proposed areas of concern. And so that's certainly something that the committee can consider, is to have my office provide you with advice in terms of the scope of those grounds and the application of those grounds, but not preventing the government or any witness to propose and raise a concern, but keeping this committee and ultimately the House with the last word on accepting or not that interpretation.
Thank you very much, Mr. Dufresne. And Mr. Oliphant.
Thank you, Mr. Chair. I almost raised a point of order or privilege, I wasn't sure which, during Mr. Bergeron's intervention, but decided you would probably rule that it was a point of debate. I do want to say two things. One, I think in a careful reading of my remarks with respect to what I said, perhaps partisanship, I was very careful in that to also acknowledge the validity of this motion and its intent. I coupled them in very carefully in my remarks to ensure that I understood that this is a valid motion, and in some circumstances, I think I would be supportive of it. At the same time, I recognize that there is a wave of requests for documents coming in many committees that appears in my mind to be of a partisan nature. And that is my opinion, and I will stress it. But I wanted to say that I would say 95% of my intervention was about the merits of the case being made by Mr. Genis and Mr. Chong and Mr. Harris. Secondly, I would say it felt like a scurrilous attack on character to assert that my reservations about this had to do with information that I felt should be hidden. Nothing is further from my intent as a parliamentarian, and an attack on someone's character is inappropriate, and I would like that to be withdrawn and apologized for. Thank you very much.
Thank you, Mr. Oliphant. Mr. Genis.
Well, thank you, Mr. Chair. Some of that is not subject matter that I want to get in the middle of, but I'll just say if we take at face value the expression of intent by all members, which is to get this motion or something very similar to it adopted, then I would just very much encourage in the time we have left, in order to ensure that we're really delivering on that stated intention, to get these amendments that have been discussed on the table, and for us to be able to proceed to a vote on those amendments as well as on the main motion. In response to a couple comments and questions, to say very briefly, we need to underline no public disclosure is triggered by this motion. Full stop. No public disclosure of documents is triggered by this motion. This motion is the committee sending for documents, creating a mechanism by which it can review the documents, and discussions about the issues and challenges related to national security, ongoing investigation, commercial sensitivity, privacy, whatever that inform questions about public disclosure. Those are questions we will need to consider carefully and we will need advice on, but we can't consider them until we have the document. This motion is about sending for the documents and then allowing us to make a determination at that point. Again, no public disclosure is triggered by this motion itself. The other point, just in response to Mr. Oliphant's earlier comments, is that we are not seeking documents from the RCMP. We are seeking documents from the Public Health Agency of Canada and its subsidiaries. So to questions about ongoing investigations, of course, that should inform considerations around what we disclose. But it is important to say and to recall that Mr. Stewart himself said that he didn't have information about the ongoing investigation. Any information about an ongoing investigation is in the hands of the RCMP, and we are not even seeking documents from the RCMP. Mr. Harris had raised the question about, do we need all of these documents? Is there some narrowing that we can propose in this motion? What we need to find out very clearly is why these viruses were sent, the protocols and protections around that, why these scientists were removed, what were the issues there, and what broader questions does this raise for the way in which national security is protected in these sensitive environments. We have narrowed it to the extent of asking for documents from a particular agency, but I don't really think further narrowing can be done, because it's only when we see the documents that we'll be able to know what pieces are where, and then to decide what is really important, what can be disclosed, what can't be, and so forth. And finally, I'll just say that Conservatives are supportive of the general direction of Mr. Harris's proposed amendment, something like saying that these documents would be distributed to members kind of concurrently with them being referred to the law clerk and parliamentary counsel. I think it would be a fairly minor amendment as well if Mr. Oliphant wanted to propose adding in that we would invite advice from other public bodies at the discretion of the committee. If in addition to seeking advice from the law clerk and the parliamentary council about what to disclose, there are other public bodies that would want to provide us with advice in writing. I assume the Public Health Agency of Canada would provide us with advice in writing about what to make public and what not to make public, regardless of whether or not we asked for that advice. So those are all fairly minor points, I think, and some of these specific issues around disclosure we can explore once we have the documents. But the main point is, Mr. Chair, if we take at face value the stated intention of everybody, then let's make sure we get this done, because this is clearly important, clearly in the public interest, and we have this facial, at least, acknowledgement of the rights of parliamentarians in this case by all members of the committee.
Thank you, Mr. Jennis. Mr. Harris, I actually was going to go to you. I was going to ask you if you wanted to propose your amendment, but you've used the raise function, and I'll leave that up to you.
Yeah, thank you, Chair. And I want to thank Mr. Jennis for actually providing some clarification so that, we are, from his comments, aware of what it is specifically is being has raised his interest and I think the public interest. So I'm happy to have that clarification on the record, and I will take up this opportunity to move my motion, and it would be as follows: that after in paragraph B of the motion, after the words Parliamentary Council, remove what's left of that B and say that the Parliament Law Clerk and Parliamentary Council discuss with the committee in an in-camera meeting information contained therein, which in his opinion might reasonably be expected to compromise national security or reveal details of an ongoing criminal investigation other than the existence of an investigation. So the committee may determine which information is placed before the committee in public. And I can read that again. Many of the words are there already, but I put some in front of them, so I repeated them all. So I'll read that again slowly so that the interpreters can have an opportunity to do it once more. The whole of paragraph B would now read: the law clerk and parliamentary council discuss with the committee in an in-camera meeting information contained therein, which in his opinion might reasonably be expected to compromise national security or reveal details of an ongoing criminal investigation other than the existence of an investigation, so the committee, or so that the committee, may determine which information is placed before the committee in public.
Thank you, Mr. Harris. Madame la greffier, avez-vous...
Madam Clerk, do you have the text? I do not have the text with me. I don't know whether it would be possible to send it to me or repeat it again. I'm missing a few words. When I say the text, I just wanted to know whether you had time to write it down. So I'd ask Mr. Harris to repeat it. Thank you, Mr. Harris.
Yes, I'll be happy to. I have it written down, so I'm just reading it out from my notes here. And that would be that B would now read as amended: the law clerk and parliamentary council discuss with the committee in an in-camera meeting information contained therein, which in his opinion might reasonably be expected to compromise national security or reveal details of an ongoing criminal investigation other than the existence of an investigation, so that the committee may determine which information is placed before the committee in public.
Thank you very much, Mr. Harris. Madam Clerk has it. I see thumbs up. That's good to see. Thank you, Mr. Harris. I now see Mr. Rajaskalas wishes to speak.
Thank you, Mr. Chair, and I guess good afternoon now to colleagues. I'm tempted to apologize here because I missed the first hour. I wasn't able to attend, and Mr. Cerbero was sitting in my place. I've been following along though, and certainly do remember the previous meeting that we had that led to this one. I, to the best of my ability here in following along, I still have a concern that we are going down a path that could compromise an ongoing investigation. I think that's a real live issue. And if colleagues want to put forward arguments that can alleviate that concern, I welcome that. But at this point, I have not heard anything that would sway my view on that. I had the concern all along. I think I raised it, Mr. Chair, in the meeting that we had previous to this. But opposition colleagues seem to be of a different view. I'm all ears. I would love to hear more, but I think that before the committee moves in a particular direction here, that we think very carefully about the need to preserve the integrity of, as I said, an ongoing investigation. I'll leave that to the committee to consider. Thank you.
Thank you very much, Mr. Vargas-Caldas. Mr. Harris, I see that your raised hand is up. You wish to speak again at this point? No,
left up from the previous. Okay.
Thank you very much, Mr. Oliphant.
Thank you very much, Mr. Chair. And I'm predisposed towards the amendment, but I have another concern that I think I want to do a sub-amendment to that amendment. I think that we have a real problem. I don't mean we as in the government. I think we as Canadians in giving 10 days to an agency that is seized with the largest public health pandemic in Canadian history, and giving them 10 days to find and translate an unknown number of pages of documents. While we have a long weekend, you'll know that Friday and Monday are statutory holidays as well. So we take a long weekend in there, which I am hoping that our officials will be able to get some time with families given the year that they've had, and that to have them comply to this within 10 days, I think is unreasonable. And I think Canadians would see it as unreasonable. So I would like to make a sub-amendment to change from 10 days to 30 days, Mr. Chair, and perhaps that would then take precedence over the amendment that Mr. Harris has suggested. So the sub-amendment is to change from 10 days to 30 days.
Mr. Chair, just a point of order on that.
Mr. Jennings, I think you're going to point out that the 10 days is in the main motion, not in the amendment.
And it's not in the section that was amended by Mr. Harris. So Mr. Oliphant is welcome to raise that as a point of discussion, but it is not germane to the amendment that we're currently discussing.
So I will give that as a notice of motion then, that if the amendment is done, I would like to come back to the time.
Thank you. I'll do that. We'll do that. But of course, so we're first on Mr. Harris's amendment. Is anyone else wish to speak to Mr. Harris's amendment? Motion to amend, that's what I should say. Proposed amendment. Seeing no one wishing to speak to Mr. Harris's proposed amendment, I would ask the clerk to conduct a vote on that amendment.
Thank you, Mr. Chair. If I may, just one point of clarification, perhaps a question to Mr. Harris. If we change the B section to what he proposed, are we still going with the C section as written in the original motion? That provides for an in-camera meeting with the law clerk within 7 days of the conclusion of his redaction of the documents in order to determine which documents could be made public.
Thank you very much, Mr. Harris.
Thank you, Madam Clerk, for pointing that out. That I guess would be a consequential amendment, that the documents may well be redacted after the meeting that we hold in camera. So I think C would have to be changed as well. So I think that if perhaps we could deal with the amendment first, and then make an amendment to section C that follows that. It would if I had been comprehensive, I would have done both at once. But I think the principle that we were pointing out was the important thing to get before accepted by the House. I can deal with that after this motion is dealt with.
Thank you, Madam Clerk. I don't see any problem with going on that basis. Do you?
No, it's all good.
Thank you. Please conduct the vote.
Absolutely. Monsieur Dubourg. Oh, vous êtes en sourdine.
Merci, Madame la Greffière.
Thank you, Madam Clerk. I agree with this amendment.
Mr. Fragiskatos.
Yes.
Mr. Oliphant.
Yes.
Miss Yip.
Yes.
Miss Zan.
Yes.
Mr. Chong.
Yes.
Mr. Jenis.
Yes.
Monsieur Paulus.
Oui.
Mr. Williamson.
Yes.
Monsieur Bergeron.
Oui.
And Mr. Harris.
Yes.
Okay, Mr. Chair, all yeas, it carries.
Thank you. It does carry, and perhaps I should have asked if anyone was opposed to it, because it should have occurred to me that it was going to be unanimous, but I don't think I was sure of that. And now I have Mr. Harris again.
Thank you, Chair. And looking at paragraph C, it seems to me that paragraph C is now redundant unless there's some need to determine when we would then meet to discuss the matter, but that's a different point than what's contained in C. C reads, the committee hold an in-camera meeting with the law clerk within 7 days of the conclusion of his redaction of the documents in order to determine which documents could be made public. I think that all of that is subsumed by the amendment to paragraph B. So I would simply move that paragraph C be deleted and paragraph D be renamed paragraph C.
Thank you very much, Mr. Harris. Mr. Oliphant.
Sorry, I put my hand up to add my earlier amendment, so I don't need to speak to this, and I'll be supportive of it. But I'm going to keep on the speaker's list. Thank you.
Thank you very much. I don't see anyone else wishing to speak to this motion to amend. So, Madam Clerk, would you proceed? Actually, does anyone, this time I'll ask, does anyone oppose this motion to amend? Not seeing anyone doing so, the motion to amend is carried. Now, Mr. Oliphant, over to you.
Thank you, Mr. Chair. And as I said earlier, I think that this places an unreasonable demand on our officials because we don't even know how much work is at stake in this thing, as well as the importance of making sure that the documents are available in both official languages, which is critical. And so, therefore, I would move that we amend it to 30 days, within 30 days. And if the documents are available before then, that's good. But I would say within 30 days. Thank you.
Thank you, Mr. Harris. I think that is fairly clear, Madam Clerk. It's clear to you what the wording you think of that motion is. Yes, good. I have Mr. Harris, but maybe a raised hand from before, and then I have Mr. Jenis. So, okay, Mr. Jenis.
Well, thank you, Mr. Chair. Look, I'm open to the discussion, but the reality is these documents already exist. We requested information and documents last week at Monday's meeting. So the motion calls for 10 days from the adoption of this motion, but we are already about 10 days from the original request for information. And we have cases, for instance, an access to information request from CBC where documents were provided about this issue in heavily redacted form. These documents have been requested and compiled before. They provided in redacted form. We're asking for them in unredacted form. And the Public Health Agency has already had substantial notice of the committee's interest in this issue. So I don't think it's a correct characterization of the facts to suggest that that all of a sudden now it's this new information surprising the public health agency that we want this information that they have to scramble to get it. Far from it. This is an important issue. There are many political factors going on that might interrupt the work of this committee, and I think it is important for us to ask for a clear timeline that reflects the fact that these are documents that already exist, that the Public Health Agency has known for a long time we have an interest in. So that would be my general inclination on this.
Thank you, Mr. Jenis. I don't see anyone else wishing to speak at this time. Therefore, I guess there is opposition, so we'll have to take. Mr. Harris, I'm sorry, you did have your hand up. Pardon me. Please go ahead.
Yeah, I hear Mr. Genuis say that he's willing to be persuaded or compromised. Is there another number less than 30 but greater than 10 that he would suggest by way of assisting other members in determining how they would vote?
I have no one else wishing to speak. Mr. Jenis, did you wish? Yes, I see your hand is up.
Well, I'll just briefly say that I suppose the members planning on casting the decided vote can propose the number that they think is reasonable. I just hope that the number of days we apply takes into consideration that there has already been 10 days or thereabouts since the original request for information at the original meeting. So in effect, I would say that asking for 10 days from the adoption of this motion has given the Public Health Agency 20 days, which is not quite 30 days, but is closer. So Mr. Harris, if you want to propose a number, it seems like you may be the deciding vote here, but I would just suggest, given the fact that the process is far from over once we get the documents, that we have to then review them and consider what to make public and so forth, that we need to try to push this forward in a timely way.
I have the hand of Mr. Harris still up, I think.
Yeah, well, I guess
Mr. Oliphant and then Mr. Dubois, and I think perhaps from the indication of the clerk, someone in the room also wishes to speak. Madam Clerk, who was that be?
Yes, Monsieur Bergeron raised his hand a few minutes ago.
Thank you very much. So I have Mr. Harris, Mr. Dubois, Mr. Oliphant, and Mr. Bergeron.
Well, I just would say, I guess we can vote on this.
Point of order.
On the point of order.
Just to clarify, I will testify or witness Mr. Bergeron. He had his hand up quite some time ago.
Okay. Yeah. Perhaps the clerk could assist me, if she can, with the order that she has.
If I may, Mr. Chair, I have Monsieur Bergeron, Monsieur Dubois, and then Mr. Oliphant.
Fine. All right. Monsieur Bergeron.
Mr. Bergeron. So, Mr. Chairman, in the spirit of compromise, as you know, I always try to find a compromise. On the basis of what Mr. Jenis just said, the agency already had 10 days to prepare, and since Mr. Oliphant seems to want us to allow 30 days for the agency to produce the document, I propose a sub-amendment to the amendment proposed by Mr. Oliphant and allow them 20 days, which will be a total of 30 days to satisfy Mr. Oliphant. Thank you very much, Mr. Bergeron. Mr. Dubois. Thank you, Mr. Chairman. Well, look, I listened to the arguments by my colleague, Mr. Genuis, with great interest. I think that the arguments put forward by Mr. Oliphant are perfectly sensible. It's not the agency itself that's going to produce the translations. It's the Translation Bureau, and we know that all committees, everyone is asking for translation. So from that standpoint, I think that asking for 30 days is reasonable in order for us to have all documents in both official languages, which is very important. Thank you, Mr. Chairman. Thank you, Mr. Dubois. Mr. Oliphant.
Mr. Chair, I was left out of the order there after
well,
I have
you on the list. I appreciate the clerk's assistance. I don't think that, so I have you now on the list after Mr. Oliphant.
No, what?
Sorry?
You had called on me because you thought I was next. You then called on Mr. Bergeron because he was indeed next, as was pointed out. But I think I was to follow Mr. Bergeron.
That may be. Look, I'm going to have to go back to the clerk to assist me too, because I may have written it down wrong. Madam Clerk, please.
So I had Monsieur Bergeron, Monsieur Dubourg, Mr. Oliphant, and then Mr. Harris.
So very well, I'll accept this, the clerk's.
Thank you, Mr. Harris. Mr. Oliphant, please.
I will be fast to hear from Mr. Harris. I would still affirm that I do not believe it would be appropriate for an agency to assume a decision by committee is going to necessarily happen. And so I don't believe that it would be common knowledge that we are going to do anything, and to read the mind of a committee would not be an expectation that would be reasonable. Therefore, I will still assert that I think it should be 30 days to give time for appropriate translation and to make sure that the documents are adequately given to us. Thank you.
Thank you, Mr. Oliphant. Mr. Harris.
Yes, I just was intending to speak along the same lines as Mr. Bergeron, noting that 10 days has passed and these documents have already been, or many of them would have been subject to an AKIP request. So it's not the searching exercise that goes on. And then the next 10 days are non-parliamentary days. So it does give time for for translation to be underway and for work to be done. So a reasonable compromise, I think, would be 20 days or 21 days, taking Mr. Oliphant's outside number.
Thank you very much. So I think we have a sub-amendment on the floor from Mr. Bergeron to change to the 20 days instead of 30 that Mr. Oliphant proposes. I don't see anyone else currently wishing to speak. Does anyone oppose? Did someone oppose the change to 20 days? Perhaps they did.
Sorry, Mr.
Okay.
Chair.
Yes, Mr. Williamson.
Just a point. When I was going to suggest 10 working days, but when we're talking now 20, that is 20 actual calendar days. Is that correct? That is
my understanding, but I'm going. You know what? I think that maybe the law clerk could answer that question, unless it is the clerk who should answer it. So
it would be 10 calendar days.
It is,
yes.
okay,
yeah.
Which is virtually the same as 3 weeks, or the 20 days that Mr. Bergeron suggested. Thank you. Sorry, but that, I mean, 10 working days is almost identical to 3 weeks. Yeah, or yeah. I'm satisfied with 20. It's close enough.
So then no one opposes, I think, the change to 20. No, Mr. Oliphant? Oh, okay. Well, I'll take a vote then. We'll take a vote on that. Madam Clerk, please proceed with the vote.
Oui, merci. Donc, c'est sur le...
Thank you. So this is on Mr. Bergeron's sub-amendment suggesting 20 days. I'll start with Mr. Dubourg. I'm against.
Katos.
Against.
Mr. Oliphant.
Against.
Miss Yip.
Against.
Miss Zan.
Against.
Mr. Chong.
Yes.
Mr. Jennis.
In favor.
Monsieur Paulus.
Oui, merci.
Mr. Williamson.
Yes.
Mr. Bergeron.
Mr. Bergeron say yes.
C'est bilingue. Merci. Mr. Harris.
In favor.
Okay. So, Mr. Chair, yes pour 6, nays contre 5, it does carry.
So now I think we're back to the motion to amend of Mr. Oliphant as amended to 20 days, right? Any debate on that? Not seeing anyone. Yes, Mr.
I think there's a
Jennis.
consensus to adopt it, Mr. Chair.
Well, I was going to ask that. And does anyone oppose adopting that amendment?
Yes, I will be opposing it.
All right. In that case, I will ask the clerk, not seeing any hands up to speak, I'll ask the clerk to take the vote.
Thank you. On the motion on the amendment as amended, Monsieur Dubourg.
Je suis contre.
Mr. Fragiscatos.
Against.
Mr. Oliphant.
Against.
Miss Yip.
Against.
Miss Zan.
Je suis contre.
Mr. Chong.
I vote for.
Mr. Jennis.
In favor.
Monsieur Paulus,
Je vote pour.
Mr. Williamson,
I vote yes.
Monsieur Bergeron,
En faveur.
Mr. Harris.
In favor.
So yeas pour 6, nays contre 5. It does carry.
So the motion to amend as amended is carried, and we're now back to the main motion as amended. Does anyone wish to speak to it? Not seeing anyone wishing to speak to it, I will ask the clerk to conduct the vote on the main motion as amended.
Thank you. Monsieur Dubourg.
Madame la greffière, je vote.
Madam Clerk, I vote against.
Fredus-Caros.
Against.
Mr. Oliphant.
Against.
Miss Yip.
Contre.
Miss Zan.
Je suis contre.
Mr. Chong.
I vote for.
Mr. Jennis.
For.
Monsieur Paulus.
Je vote pour.
Mr. Williamson.
I vote yes for.
Monsieur Bergeron.
En faveur.
Mr. Harris.
In favor.
So yeas pour 6, nays contre 5. It does carry.
The motion is carried. And so,
Mr. Chair, just a point of order before you adjourn.
Jennis? Yes, please.
Yes, the motion that we adopted doesn't prescribe a specific timeline for hearing from the law clerk, but I hope there would be a consensus in the committee to prioritize hearing from the law clerk as soon as possible in our committee's agenda as soon as these documents are received. I assume that would be a given, but I just wanted to put it out there because we've discussed other business, but I think this should be a priority matter once we receive the documents.
So I guess what you're saying is you're proposing that once we receive the documents, we would probably postpone part or all of the meeting that was then scheduled following that to the next date. Is that correct?
Exactly. Yes. That the proposed discussion with the law clerk would occur right away once we receive the documents.
Thank you, Mr. Harris.
Yes, I think the law clerk should be the one to tell us that he's ready to discuss them. I don't think it's immediately upon receipt. He obviously has to review them and come to his conclusions as to what he sees as being matters that ought to be raised with the committee, his opinions, etc., that are contained in the motion. So he will probably have to have a little time to look at that. So we would hopefully hear from him once he has received the documents, and then an indication as to when he's ready to provide his advice.
Thank you, Mr. Harris. I think that the same notion that Mr. Jennis has in mind. Mr. Jennis?
Yeah, no, I agree with Mr. Harris. I just the point being as soon as reasonably possible that certainly we wouldn't allow our committee schedule to be the barrier, and that we would encourage our law clerk. I know he works very diligently for parliamentarians, but just encourage him to be able to connect with us as soon as he's available, and that we would certainly make ourselves available as quickly as possible.
Yes, I trust and hope this won't affect his weekend. Madam Clerk?
I have Monsieur Williamson in the room.
Mr. Williamson, please.
Yes, thank you. Just a small detail to confirm. So the 20 days then takes us to April the 20th, which is actually easy because tomorrow's the 1st, which I think is, I just want to ensure we're all in agreement that is the day we expect to have the response from the health agency. Okay, and I hear yes, it is. So my point previously about 10 working days would have taken us to April 16th. So hardly a difference, and I'm very glad we were able to agree on Mr. Harris's amendment. Thank you, Mr. Harris.
Thank you, Mr. Harris. I see you have a raised hand.
Well, that's a lingering hand, sir.
Okay. Seeing no one else wishing to speak at this time, I have the impression that there may be consent to adjourn. Does anyone have a problem with adjourning at this time? I don't see anyone adjourn. So therefore, this meeting is adjourned. Thank you very much.
Merci.
Thank you, Chair.